Reports indicate that federal marshals have begun taking control of some of Donald Trump's properties. The judge overseeing the case flatly rejected the arguments made by Trump's legal team. Legal analysts say her ruling was unusually forceful. Trump's lawyers had asked the court to halt the seizures, claiming they were unfair, politically driven, and damaging to his business operations. The judge was unconvinced, dismissing those claims outright. In her words, Trump's arguments were frivolous, legally unsupported, and an affront to the integrity of the court. And this isn't just about a wealthy real estate developer losing a few assets. What we're witnessing is the methodical unraveling of the Trump organization's most prized holdings. Properties that have dominated the Manhattan skyline and served as the backbone of Trump's public image for decades are now being inventoried, appraised, and positioned for seizure to satisfy a massive civil fraud judgment. When federal authorities start placing legal holds on Trump Tower and attention turns to buildings like 40 Wall Street, the reality of accountability becomes impossible to dismiss. A business empire built over half a century, long showcased as proof of Trump's supposed genius, now risks collapsing because of years of false valuations and financial deception. Here's how it reached this point. The case stems from a sweeping civil fraud lawsuit brought by New York Attorney General Letitia James against Trump, his adult sons, and the Trump Organization. Her office spent years investigating allegations that Trump routinely inflated property values to secure favorable loans and insurance coverage, while simultaneously undervaluing those same assets to reduce his tax burden. These were not small errors or technical oversights. Investigators found that Trump exaggerated the size of his penthouse by nearly 3 times, valued Mar-a-Lago at more than $500 million, despite restrictions that made it worth far less, and manipulated appraisals across his entire real estate portfolio. The case went to trial in late 2023. The court concluded that Trump had engaged in persistent, repeated fraud over decades. In February 2024, the judge issued a judgment exceeding $450 million, including interest, and ordered Trump to surrender profits obtained through fraudulent practices. Trump quickly filed an appeal, but under New York law, an appeal does not stop enforcement unless the defendant posts a bond covering the full judgment plus interest. In practical terms, that meant Trump needed to secure close to $500 million in cash or assets. Without it, the seizure process could move forward. According to reporting from Politico in March 2024, Trump's legal team admitted they contacted more than 30 surety companies in an effort to secure the required appeal bond. Not a single one agreed. The reason was simple and devastating. Trump's own fraud judgment made his real estate valuations unreliable. The very case he lost established that his asset values couldn't be trusted, and no serious financial institution was willing to gamble hundreds of millions of dollars on collateral a court had already deemed fraudulent. And let's pause for a moment and be honest. Asset seizures do not happen to former presidents under normal circumstances. They don't happen to genuine billionaires with deep liquid reserves. They happen when someone has run out of legal roadblocks, when courts have ruled decisively, and when the debtor either cannot or will not pay what they owe. The fact that this process has reached the seizure stage says far more about Trump's real financial condition than decades of self-promotion ever did. This is where the situation takes a dramatic turn. Multiple outlets, including CBS News and CNN's legal correspondents, report that the asset seizure process moved into full gear this week. New York state attorneys, accompanied by federal marshals and court-appointed receivers, began arriving at Trump-owned properties armed with court orders. At 40 Wall Street, the historic Manhattan Tower Trump has long described as a crown jewel of his empire, officials were seen entering the building to inventory assets and establish legal control. At Seven Springs, Trump's expansive estate in Westchester County, court-approved appraisers were granted access to conduct formal valuations. Even Trump Tower, the gaudy, gold-clad Fifth Avenue landmark that has symbolized Trump's brand since the early 1980s, saw legal officials arrive to begin assessing how the property could be sold or transferred to help satisfy the judgment. Trump's legal team threw everything they had at the court to stop this from happening. They filed a series of emergency motions arguing that seizing Trump's properties would cause irreparable harm, not only to Trump himself, but to tenants, businesses, and employees who operate within those buildings. They claimed the enforcement was politically motivated, pointing to New York Attorney General Letitia James's campaign rhetoric and accusing her of carrying out a personal vendetta. They even argued that moving forward with enforcement before the appeals process concluded violated Trump's due process rights. According to NBC News, Trump's lawyers painted a dire picture, warning that forced asset sales would collapse property values, harm innocent third parties, and amount to an unconstitutional taking by the state. The judge was unmoved. In a written ruling issued this week, one legal experts are calling devastating, Judge Engoron addressed each argument and dismantled them one by one. CNN legal analyst Jeffrey Toobin, who reviewed the full opinion, noted that the tone was unusually blunt for a judicial ruling. The judge emphasized that Trump had been found liable for fraud after a lengthy trial in which he was given every opportunity to present his defense. This outcome, she wrote, was not unexpected or abrupt, but the natural and foreseeable result of conduct the court had already determined to be persistent, egregious, and deliberate. The judge then zeroed in on Trump's claim of irreparable harm, making clear that any damage he now faced was entirely of his own making. If Trump wanted to prevent asset seizures, the court explained, he had two straightforward choices: avoid committing fraud in the first place, or post the legally required bond to pause enforcement during the appeal. His inability to secure that bond, the judge stressed, was not the court's concern. But the ruling didn't stop there. Taking on the political persecution argument